do have a couple of quick questions here from today's audience. Jonna, we've got a question here for yourself. If one's company was perhaps facing a lot of budget, maybe staffing constraints as a result of the current pandemic, and it's of the utmost importance to get compliant, should one perhaps prioritize what needs to be done when it comes to maybe putting together a compliance project?
So I think the number one thing to do, I think you've heard it several times so far, is to be sure, think about that private right of action and make sure that the data that Ken was talking about, the more limited subset of data, make sure that that stuff is encrypted. So that doesn't take, that should be a high priority item at the very top. And then the second thing is you really do have to get a handle on your data flows. You want to be able to get your privacy policy conformed to what's required and get it posted. But to do that, you've got to understand, what do we have? Where do we get it from? What do we do with it? And there's not really a shortcut to that, but I think it's helpful to kind of go from that chart. But those are the two things that I think you should prioritize at the top. Make sure that you're encrypting things just to kind of as a safe harbor, avoiding the whole issue of the private cause of action, and then working on your privacy policy and getting that posted.
Thank you so much. Ken, we've got a quick question here. It dropped in during your segment. It's open to all of our panelists as well, but perhaps you want to lead us off. And the question is, are there any international shoe type challenges in the pipeline for the CCPA? And the example that the person gives when asking the question is, merely having a website does not create sufficient minimum contacts for personal jurisdiction. Ken, apologies if you may have missed that. The question again was, are any international shoe type challenges in the pipeline for the CCPA?
Yep. Yeah, sorry about that. I had my mute button on. I'm not aware of any international shoe, challenges as of yet. But, as we all know, the CCPA applies to only those companies that, quote unquote, do business in California. And so, potentially with respect to, an enforcement proceeding, they may come to be. However, there's kind of an infinite loop kind of an approach there, or whereby if a company might not technically be having any facilities in California, if they are proactively collecting data of California residents, the argument that while they don't have a presence in California physically, would be belied by their activities that are collecting data of California residents. So in one way, you might have the technical argument, but on the other hand, the activities that give rise just to the data collection may ultimately, undercut that international shoe argument.